Welcome to Legal Environment of Business. We're going to begin our study by first discussing what is law, second, looking at some of the sources of law and how they interact with each other, and then last, we'll take a look at the differences between civil law and criminal law. So, to get us started, what is law? Law is really just enforceable rules established by a government that governs relationships within society. It governs how people interact with each other. You could think of divorce laws, child custody laws. It also governs how businesses interact with each other and with their customers. You can think of contract laws, the Uniform Commercial Code, which we'll talk about later in the semester. And it also governs relationships between the government and its citizens. You could think of regulations that certain businesses have to comply with, probable cause as it relates to a criminal case. And so the law really governs these relationships. What is the function of the law? Well, it's really there to provide stability and predictability. You can imagine how chaotic and difficult it would be if we didn't have law to sort of govern our behavior and guide our behavior as a society. And so law provides that stability and predictability. Of course, in the United States, we do have two legal systems. We have a federal system, which has its own courts, its own laws, and then each state has its own system, its own statutes and courts. And so we'll see a little bit today of how those two systems interact with each other. So what are our sources of law? We're going to look primarily at the four main sources of law, which is the Constitution, statutes, case law, and administrative regulations. Now, there are some other sources of law that come into play and that are worth mentioning, and those would be executive orders, procedural rules that apply in the courts, and international law. But we're not going to talk about those today. We're going to look at the first four major sources of law. And so first on our list is the Constitution, and I'm talking specifically here about the U.S. Constitution. Each state does have its own constitution as well, but our discussion today is going to focus on the United States Constitution. If we were going to have a hierarchy of laws, the Constitution would be at the top because it is the supreme law of the land. And there's a clause in the Constitution called the Supremacy Clause, and it basically says that the Constitution is the supreme law of the land. So Congress cannot pass a statute, a judge cannot issue a decision that violates the Constitution. Now within the Constitution, what you will hear about the most is usually a part of the Constitution called the Bill of Rights. And that's the first 10 amendments to the Constitution. That's where we find freedom of the press, freedom of religion, free speech, all of those things that are discussed in the text and that you probably hear about in the news from time to time. So that's the Constitution. Our second source of law is statutory law or statutes. And this is laws that are created by a legislative body. So at the federal level, we have Congress passing laws, creating statutes. And then at the state level in Tennessee, we have the General Assembly that is passing laws and creating statutes. So statutes, if we had a hierarchy of laws, statutes would be in the number 2 spot. Third, we have court decisions. And you can think of this as judge-made law, or you'll often hear it referred to as the common law. The common law originally was a set of legal principles that had developed over time in England, and when the Pilgrims came to the United States, they brought with them those English common law principles, and so that essentially became the common law of the United States. Now, over time, the U.S. has developed its own common law principles, but we do have our roots in the English common law system. Within the area of court decisions, there's a concept called stare decisis. But before we talk about stare decisis, we need to understand the concept of precedent. And precedent is basically a court decision that furnishes an example or authority for deciding subsequent cases. So, for instance, if you were involved in a car accident today, and there was you had sued someone for the injuries that you suffered, and so the court was trying to decide, should we hold this person responsible for the injuries that you've sustained? Your attorney would probably try to find some similar cases that have been previously decided that had facts similar to yours and applied law that was relevant to your situation and that came out favorable to you, and would try to argue to the court, hey, in the past, when the courts have faced cases like this, here is how they've decided. And so you should follow that precedent and decide this case in favor of my client. And so that essentially is the concept of stare decisis. Looking at prior cases with similar facts and law and applying those to cases that are currently before the court. Now, some advantages of stare decisis is it helps provide that uniformity and predictability that we need in the law, and it also allows the judge to make a faster decision because he can look at those past decisions and say, yes, this makes sense, we should follow this. A downside to stare decisis is that it can be slow to change. The courts are slow to develop new precedent, and it's usually a court of appeals or a Supreme Court that establishes new precedent, and so it can be a slow process to change. Our fourth source of law is administrative law or administrative regulations, and these would be regulations that are created by a government agency. For instance, the Federal Trade Commission or the Federal Communications Commission, or at the state level, the Tennessee Department of Revenue or the Tennessee Department of Human Services. These administrative agencies get their power from a statute. Congress at the federal level will pass an enabling statute that creates a federal agency. For instance, the Social Security Act that created the Social Security Administration. Congress does not have time or the expertise to sit there and fill in all the rules and requirements and specifics that would be necessary for the Social Security Administration to operate. I mean, it's hard enough to get Congress to agree on anything, so you could imagine how difficult it would be to get them to agree on all the specifics. So what they'll do, they'll pass what's called an enabling act or an enabling statute that creates the agency and delegates to that agency the authority to make regulations necessary to carry out that agency's purpose. So for the Social Security Administration, they create regulations that determine when is a person considered disabled so that they can receive Social Security disability. It's the agency that has the time and the expertise to do that better, and they can do a better job of that than Congress could have. And so that's an example of administrative law and administrative regulations. So it's neat to see here how each of the three branches of government has a hand in creating law. We have the legislative branch creating statutes. We have the judicial branch using the common law and making court decisions. And then we have the executive branch through the administrative agencies creating these administrative regulations. Now, one question that can come up here is, hey, what happens when there's a conflict of law? If there's a conflict between, for instance, a statute and the Constitution, well, the Constitution would win, right? If there's a conflict between a statute and a regulation, an administrative regulation, the statute would win. But what happens if there's a conflict between, say, a statute and a court decision? Well, it can be a little more complicated at that point because the courts have the authority to determine whether something is or is not constitutional. And that's the concept of judicial review, which we'll talk about next week. But basically, there can be some play there between the courts and the legislature. If a court strikes down a statute, the legislature can go in and try to rewrite it to make it comply with the court decision. We had mentioned just a minute ago that there's a federal system and then there are state systems. What if there's a conflict between a federal statute and a state statute? Well, generally the federal statute is going to control. That's our general rule, that federal law trumps state law. So what I want to end with today is just this chart comparing the civil law versus criminal law. Just a couple things that I want to point out here. First, the difference in who files the lawsuit. If it's a criminal case, it's the government that initiates and prosecutes the case. If it's a civil lawsuit, it's the injured individual who brings the lawsuit. The standard of proof in a criminal case, I'm sure you're familiar with, you hear this on TV, proof beyond a reasonable doubt. That's a much higher and heavier burden than what we have in a civil case. In a civil case, the burden of proof is preponderance of the evidence, which is, think of that as 51%, just enough to tip the scales. Why do we have these different burdens of proof? Well, in a criminal case, we have a much higher burden of proof because there's so much more at stake. You could be looking at a fine, you could be looking at jail, potentially the death penalty, not to mention all the social stigma that goes with being arrested. And it also serves as a check on the government to help prevent the government from just abusing its power and resources. The last thing that I want to point out here is the difference in remedies. In civil law, your remedy may be money, or it could be an equitable remedy, a remedy in equity, something like an injunction requiring somebody to stop doing something, or an order for specific performance requiring them to go out and to do something. So that's the difference between your remedies at law, which is usually cash, or your remedies in equity that requires someone to change their behavior.